Hello again. Now, former President Jacob Zuma must go back to prison. That's the word from the Institute of Race Relations. Their comments follow Monday's Supreme Court of Appeals ruling that found Zuma's release on medical parole unlawful. The Correctional Services Department now says it will be appealing this judgment. The Institute is exploring legal avenues in light of the ruling. Well, for more on this, I'm now joined by the Institute of Race Relations, Gabriel Crouse. Mr. Crouse, good afternoon. Welcome to Today on eNCA. Thank you very much for your time. What is it about this judgment that is making you now at IRR in looking at legal avenues that you can take?
Thank you very much, Mr. Mayani, and greetings. There are two main aspects that are very concerning. The one is that the SCA judgment effectively said the Correctional Services Department unlawfully released Zuma, but now that same department can decide whether to release him again without him serving his original 15 months by pretending that it counted as a lawful medical parole time served. That seems to be saying you made a mistake and now to solve it, you can repeat the mistake. So that seems to be confusing and concerning. However, the Correctional Services Department has said, even though we've only been ordered to bring in Mr. Zuma for a mere moment, and then we can theoretically release him immediately, even that is too much. And they are filing their appeal against that. So the second major concern is that, in our opinion, there is some merit to Zuma's complaint that he's been treated unfairly on the basis not that he shouldn't have been released on medical parole, but rather in the reasoning that the Supreme Court of Appeal has applied. They treated him like an ordinary criminal, which is someone who has had a fair trial in terms of the Constitution Section 35 definition of a fair trial, and that therefore he's now a sentenced offender who fits into the parole system. But we say he was never an accused person. He never had a fair trial in terms of Section 35. Instead, he had a different kind of trial. In Latin, they call it a sui generis trial. And this is not a new thing. Since Smuts de Lange in the 90s, our constitutional court has said, what happens if the court tells you to do something and you don't do it? You don't become an ordinary criminal. You become a contemnor. It's an own category. It's a sui generis category. And there are rules of how to treat people in that category. Now, we just want Mr. Zuma to be treated by those rules. And those rules dictate that he should go back to jail for another 13 months. But if he comes to his senses and apologizes and says, I'm ready to give evidence on state capture, then a way must be found for him to give such evidence. And once he's done so, he should be able to go back to the Constitutional Court and ask for an amelioration of the sentence, because he will have finally complied with at least part of the order.
In that rationale, would he have to then provide the Constitutional Court with some of his answers to the State Capture Commission? Because this whole matter started there when he was ordered to go and answer questions at the State Capture Commission. Or will that now be a moot point?
No, that's exactly right. This all started when the Constitutional Court said you must go give evidence about state capture. Now, and as long as he doesn't do that, the only alternative is he must serve 15 months in prison. He's only done 2 months, so there's another 13. Of course, it's true that the State Capture Commission has now exhausted itself. It's issued its report. But it's not a moot point because, firstly, the president can reignite that commission for long enough for Zuma to just submit evidence. Alternatively, he doesn't need to give the evidence to the commission. He can give it to the public, to the presidency, or to the Concourt directly. All that needs to happen is that he needs to supply the answers. That's what South Africans want.
Yeah. Now, the fact that we're reporting that the Correctional Services Department is appealing the SCA's ruling, what does that do to your process where you are currently seeking legal guidance?
Yeah, so we've been talking with our attorneys. We've been exploring avenues with some counsel. It's not finalized yet, but to my mind, someone is going to have to go to the Constitutional Court alongside the correctional services, if they are accepted, to say, we want to restore the Concourt's authority. The Concourt made an order, and the Department of Correctional Services violated that order unlawfully. That order needs to be restored in its full terms, which means that Zuma is treated like a contemnor, not an ordinary criminal, and he must go and serve 13 months, or alternatively, he must try to purge his contempt, as the lawyers say. He must try to make good. He must try to show respect for the Concord after all. And the only way he can do that is by saying he's sorry for being so offensive and by giving the evidence. I think it might be the case that the IRR needs to be the one to go and say that, because we were the ones who brought this argument in the first place, that you can't treat him like an ordinary criminal, and also you can't let him go scot-free. You've got to stick to that middle ground. You've got to stick to the rule of law, and we've got to continue to pursue the evidence of who is crooked and who is corrupt, and are they still in government? Are they still eating the money that should be going to ordinary South Africans?
Gabriel Crouse, thank you very much for your time and explanations this morning. He's, of course, head of campaigns at the Institute for Race Relations.